Welcome to Employment Law This Week. I'm George Whipple. The National Labor Relations Board is headed in a new direction this year under Biden appointee General Counsel Jennifer Abruzzo. Employers can expect more employee-friendly decisions out of the agency, as well as a new partnership with the Department of Labor. Epstein Becker Green's RyAnn Hooper is here with more.
Practitioners in the labor management relations space have become all too familiar with the fickle nature of NLRB precedent, which often changes with the change of administration. The new General Counsel Jennifer Abruzzo announced in an August 2021 memo that she would be revisiting decisions that dealt with employer workplace rules and policies and how the board reviews and looks at those and whether they are appropriate under the National Labor Relations Act. She would look at expanding the board's remedy power. Right now, make-whole remedies are the standard that are used, but she would expand beyond that. She wants to look at workers in the gig economy and misclassification, capturing some of those independent contractors and designating them as employees, and look at the board's standard for how employees are determined to be independent contractors. She also wants to expand what's considered Section 7 rights. And then finally, they would be looking at non-disclosure agreements, confidentiality agreements, and private settlement agreements, and whether those appropriately permit employers to restrict employees' behavior after the settlement is complete. The memorandum really focused on misclassification of workers, mistreatment of workers, and looking at those situations where pay of workers was inappropriate, particularly given the classification. They would share documents, share any heightened view of any potential violations, and it would be a formal process by which they could go back and forth as opposed to an informal process. Employers should be prepared for more oversight and regulation, particularly those employers that rely on third-party contractors to carry out their business initiatives. They should also be prepared for greater scrutiny of workplace rules and handbook policies, and greater scrutiny of actions taken concertedly by employees and the employer's responses to those actions.
Thanks, RyAnn, and thank you very much for watching. We'll see you next time.